Right now I want to focus on mandatory reporting. Can someone tell me what I mean by mandatory reporting? What is mandatory reporting? Who's got to report what and why?
Depending upon the state, certain professional, all professional teachers, I don't know what social workers. Yeah, social workers, doctors.
Well, depending upon the state, what? Who's classified as a reporter? And some states, Africasia, the mandatory reporters are professionals only. And who those professionals are determined by the legislature in drafting the mandatory reporting statute. Remember, we started out by dissecting statutes, and there was a reason for that, because a lot of issues surrounding children in the legal system are driven by not only the case law, the opinions of judges, but also by the statutes that are drafted by the legislature. And mandatory reporting is an example of that. Mandatory reporting involves a statute, a law that was passed by a legislature. Now, different states have different statutes. Some states, as Africasia suggested, have professionals must report statutes. Other states, like New Jersey, have what kind of statutes? Who must report in New Jersey? Anybody who knows about abuse or neglect. Or what we call more specifically all persons. We have an all-person statute in New Jersey. Not a professionals only, but an all persons. And the group of professionals who must report varies from state to state, if it is a professionals only. All persons are easy. You know, if you're an all-person state, that means everybody. But just because New York is a professionals only state, and it is, look it up on the web, you'll find the New York. Anybody ever work in New York here? Remember Jonathan Reed used to sit here. He was a grizzly veteran from Queens or the Bronx or whatever. He knows about that statute. New York has New York has a professionals mandated reporter statute. But just because New York has a professionals mandatory reporting statute and a clinical social worker nurse is required in New York State, that doesn't mean that in Mississippi, where they have, and I don't know if they do, but if Mississippi had a professionals only reporter statute, that clinical nurse social workers are required in Mississippi, because the legislature will define who the specific professionals are. And that can expand. It very rarely contracts. The list would only get longer. And the list typically gets longer when in some state, some horrible crime happens or some horrible turn of events in child protection, and then they say, well, how come she didn't report? You're supposed to report in the state. And they'd say, or the response would be, well, he or she is a substance abuse coordinator out of school, and they're not among those listed. If you ain't on a list, you don't have to report. That doesn't mean a substance abuse coordinator in New York State, if there is such a title, couldn't report. It's just that they're not mandated to report. So when you are a professionals only have to report state, it varies from state to state depending upon the list made up by the legislature in that particular state. New Jersey makes it real easy. Anybody who has can someone tell me the buzzwords? Can someone tell me the term of art, the phrase in the code that says any person must report what? What must you feel or suspicious? Reasonable suspicion. Reasonable suspicion. No, that's something else, but a reasonable suspicion that a child may be in danger. It's a little more specific than that. I think it says, we'll look at it because I don't remember. I deal with this every day. Some of you deal with this every day. That's why we must go back to the statute always, whenever there's some uncertainty, because those words are very critical in determining whether someone did not live up to their obligation or whether they did. But it's something like, because I've encountered this before, especially when I have issues with the division about whether the division ought to open on a case or not, because it says, I think, is being or has been. You see? And a question that I get when I go around the state and I present from time to time, and some of you may present as well, some of you veteran DYFS workers, on these very issues to teachers and other professionals in the field, and they may say, well, what about a child who came in and said something happened, when she was 6 and she's now 14, and it's her uncle who died? Well, I think the answer is yes. We'll look at the statute. The more confounding one, I think, is when a professional says to you, maybe it's a hospital pediatric resident, the hospitals and the social workers there and the physicians there often grapple with this because, they're over there at the ERs trying to help kids, help people, dispense medicine, deal with their physical ailments, and they don't want to breach that respect that they have, that obligation of privacy that they have with their patient. So they're very reluctant to report, especially if it's a teenage girl who's pregnant and needs, prophylaxis or some sort of, treatment for venereal disease and the like. They don't want to breach that trust. So there's constant tension in what they ought to do or what they have to do. And sometimes they'll say, and they come up with these rather interesting hypotheticals, like I said earlier, the reason why we lawyers will have a career till the, nuclear holocaust is because statutes and laws and court decisions and administrative regulations are made up by words, and words always are ambiguous and imprecise. And we come along and try to say what words ought to mean or what they were supposed to mean. That's just the way it is, and always will be. And this mandatory reporting statute, like all statutes, is made up of words. So you need to go back to that statute and see whether it fits and see whether it makes sense. And, in the case of an adolescent, that doctor may not want to report, and they may have questions about whether they ought to report. You go back to the statute. One of the questions that they ask all the time, because there are cases that always don't fit what the statute says, but you wonder whether you have that obligation or not, and this is the one where we have a little conflict with DYFS from time to time. When I say we, the prosecutor's office, is what about a 19-year-old who is disclosing today that she was molested when she was 12 or 13? Is that a case that fits mandatory reporting statute? Now, I'm confusing it a little bit because the issue with DYFS is, do they have jurisdiction? Are they supposed to go out? Is this something, within their mandate? Okay? But to a physician in the ER or a clinical social worker or a psychologist or some other mental health professional, they may learn this from a 22-year-old and find out that 22-year-old was molested when she was 14 years old. And she may say, well, I didn't think I had to report it because she told me the abuse stopped when she was 16. It lasted for 2 years and it ended. And I have a response for that. I have a response, and my argument would be that it is a reportable condition. And can someone tell me why I think that's a reportable condition, even though you might disagree? What's that?
Because it happened when she was a minor.
Well, it happened when she was a minor, but...
The statute of limitations?
Well, that's for we lawyers to worry about, the statute of limitations. Is or was. Is or has been. That's what I rest my argument on. And we're going to look at the statute right now. I'll pull it up online or on Blackboard. And the reason why I make that argument is I think not only because I'm a slave to language and I think that I read it and that's what it means, and has been means has been, and she has been, or was, and was means was. But more importantly, why do you think it might be incumbent upon social work? It might be incumbent upon child protection to go out and investigate the circumstances of what happened to this girl, okay, today, even though she's 22 and it happened 8 years ago, and she don't even live in a family home. She lives in Bayonne. Her family lives in Patterson. Why do you think that it might be important to look into that anyway? And why do you think it was wise for the legislature to say, whether they realize this or not, and again, this is my opinion why it was wise, why do you think it might have been wise to say is or has been? Chuck?
Doubtful the person who committed the abuse stopped with other victims.
Right. Don't you want to go back to that household and see where this guy is now and who lives in that house now? Might there be other children who reside there? Well, he's 75 and this, that, or the other thing. But he might have grandchildren. Who knows? You know, his access to children may have never ended. And you won't know unless you look. And I think Child Protective Services has an obligation to go back and look in those cases. And quite frankly, I'll change the facts. And this is where people begin to go, well, you know, I don't know, that's different. She's 34 and lives in Bayonne. She's 44 and lives in Bayonne. But guess what? Gramps is still alive? Has someone here ever had an intergenerational molest case? Come on. Have you ever had a case where the child was molested by the grandfather, and you later learned when debriefing the mom that he molested her in the Dominican Republic, or he molested her in Sicily, or he molested her in some other place and time? Have you had one of those cases? Have you been around long enough to stumble upon those? I wouldn't say they're rare. They're not common, but they happen from time to time. I've prosecuted some like that. There was a case I had in Totowa, a man named Ed Sullivan. He was, I don't know, in his 80s or late 70s or mid-70s when we prosecuted him. He was an old man. And he molested every girl in his care, all of his daughters. They were all adopted children. Not that that mattered, but just an interesting fact. They were 4, maybe 5 adopted girls. He molested them their entire youth in brutal ways. He was a sinister, corrupt Christian. He would cite the Bible, and he was just a terribly evil man. Molested all the girls for many years. They grew up to be troubled, as one might expect, in a variety of ways. They went on to have families. They certainly didn't wind up in the gutter, unfortunately, like some of these victims do. Interestingly, none of them stayed in the Passaic County area. Who was in the New England, who lived in Kansas, who lived in Sherman Oaks, California, who lived in Texas. Some of them became very successful. And it was when the one who lived in Sherman Oaks, California, realized that her daughter was now being molested by Grandpa, that it got reported to us. So her daughter, who was 12 or 13 at the time, became a surrogate, if you will, for this guy's prosecution for everything he ever did. I treated him not for the rather limited fondling he performed upon the granddaughter. I looked at him as a person who committed a life of atrocities. And we went after him and prosecuted him, and he was successfully prosecuted and went to prison. And unfortunately, because he was so old, you know, he didn't do that much prison time. But he went to state prison and was assigned to the geriatric prison in Camden. It's actually a geriatric prison, you know, 70 and over. There's a wing in Camden where they house those folks. And I remember he brought his girlfriend to sentencing. She was a young chippy. She was 68. She was there to support him. God knows what she knew about what he did. I became close after the trial to one of the women who became very successful. As you may know, how victims survive incest depends a lot upon a variety of factors. Some become overachievers, believe it or not. There was a Miss America who was a survivor of incest and achieved great things scholastically and personally and socially. You know, and some wind up, unfortunately, on the streets and in the worst of predicaments, in the worst of circumstances, whether it be pornography or drug abuse and the like. one of these five, I think it was five sisters in the case I just described, became a multimillionaire and opened a chain of Tex-Mex restaurants. She started Chevy's. Everybody hear of Chevy's? They got one over here in Clifton Commons, Chevy's. Her and her husband started Chevy's, and they eventually sold out, and they opened another string of restaurants where pretty much had the same menu type as Chevy's, called Uncle Julio's, and they recently cashed out on that. This was a woman who was among the five who were brutalized, not only sexually but physically brutalized by this man for many years. In any event, you have intergenerational molestation. It's not unheard of, and that's not the only case I ever had. I've had, one or two a year. I have a case now, a guy by the name of George Baker I'm prosecuting right now. I think I went to grand jury on him. Yeah, I did. I went to grand jury on him a couple of weeks ago. George Baker reminds me of a couple of these cases I've had where he molested all the daughters, including, it wasn't intergenerational, but there was out of the relationship, they had children that are in their 30s, and then they had another baby much, much later. She's just turned 18 or 19 now, so it's kind of intergenerational. The point is, he's old, and he's molesting someone new who happens to be much younger than the original group of children who he molested. And it gets back to the point why I am endorsing the interpretation that the Title IX mandatory reporting statute requires that persons report in New Jersey not only abuse that is happening, but abuse that happened no matter when you learn about it, no matter when. Let's take a look at the statute. Any person having reasonable cause, well, there you go, it's not a professional-only state, right? Any person having reasonable cause to believe that a child has been subjected to child abuse or acts of child abuse shall report the same immediately to the Division of Youth and Family Services by telephone or otherwise. Well, it's not as clear as I've been saying here, but I read that as the past tense. Has been subjected. Not is being subjected. Has been subjected to child abuse or acts of child abuse. When do you have to report it? Immediately, by telephone or otherwise. Such reports shall contain the names and addresses of the child, parent, guardian, or other person having custody and control of the child, and if known, the child's age, the nature and possible extent of the child's injuries, abuse, or maltreatment, including any evidence of previous injuries, abuse, or maltreatment, previous, I say, injuries, abuse, or maltreatment, and any other information the person believes may be helpful with respect to the child abuse and the identity of the perpetrator. So, in evaluating whether someone should report or not, and whether someone had the obligation to report or not, begs the question about why is that relevant? Supposing there was a social worker who didn't report a 32-year-old person who she knew was molested, and she had more than reasonable suspicion that that person was molested in an intrafamilial context. Why would a prosecutor want to know that? Why is that important? And it kind of connects back to a rather thorny case I grappled with early in my child maltreatment prosecutor career. I mentioned the first week, I think. Why does it matter? Yeah, that's the practical upshot of it. Why would we want to make sure people who are supposed to report? Because had we known, it may have prevented another child or another generation of children or some other person from being exploited. But from a prosecutor's perspective, too, what else might be on my mind?
Well, is that, even though that you may not be able to prosecute the original crime if it's 30 years old, but can they be a witness for the prosecution against the person in another case?
Who be a witness?
Like you said, the 44-year-old person. Like, that statute of limitations, because...
Oh, yeah. Well, don't even worry about the statute of limitations. You might not even have a statute of limitations problem. Not only could they possibly be a witness, yes, or they might even be able to be a victim and testify. The statute of limitations was abolished in 1996 in New Jersey. So if you do the math, it's getting higher and higher. Someone walks into my office in their mid-30s and they don't have a statute of limitations problem. They used to. But because 96 has kind of, the pages turned and 2006 has gone by, And we're in 2008. Before you know it, there won't even be any more statute of limitations problems. But yes, if there is one, and we know about that person, that might be a potential witness for any other abuse that we uncover. Their victimization might be admissible in court as corroborative of the victimization of any new victims that might be uncovered. Plus, we want to know that, going back to our first observation, we want to know that so we might be able to protect other victims. But what about the person who doesn't report? Is there a statute that speaks to them? Is there a statute about people who don't report? If they're a mandated reporter and they don't report, what?
You're fine.
Oh, yes, perhaps. And they can go to jail as well. I believe it's a disorderly persons offense, and you can get up to 6 months in jail. So you are potentially criminally liable. I don't know if I posted it on here, but yes. It's a failure to report child maltreatment or failure to report what we just described in the mandatory reporting statute is a disorderly persons offense. If you knowingly fail to report, that goes back to that woman who I charged that owned the daycare center when her 12-year-old latchkey son was hanging out and molested one of the other children after she knew that a prior child had made an accusation. I charged her with failure to report child abuse for violating that reporting statute. If you don't do what that reporting statute says, you can be criminally liable for a disorderly persons offense, up to 6 months in jail and fines, and of course the attendant public humiliation and professional stigma that attaches to that. Tyson? Convicted or charged? Charged, yeah. I mean, I think if you get charged, you probably got a good chance to get convicted. What happens is, you may not have heard of it, and I don't see it either for a few reasons. One is, once you become a little seasoned in this business, you're typically not going to charge someone who commits that offense. And what I mean by that is, we run into people all the time who have a reasonable suspicion and don't report. Forgetting about the mothers, they're a dime a dozen. I mean, but one of the most difficult things for the novice detective and even the novice prosecutor in the field of child maltreatment to cope with is the fact that many of these caregivers, the mothers typically, know about this or should have known about this or have really compelling signs that something is going on, yet they choose to ignore it or deal with it in their own way or deal with it in the family or never leave the child alone with the guy, or all kinds of foolish strategies for protecting their daughter. You run into these people, and when you first see them as a young prosecutor or a young detective, much of your passion is directed at them as well as the suspect. How could you do this? What kind of idiot are you? You made a choice over security and economics and the fact that he's a breadwinner or paying the bills or whatever your love for him is. You chose him over your daughter. And very often we see when we go to court, whether it be in civil court with the DAG or whether it be in criminal court, very often we see these caregivers sit on the defense side, sit on the side of the witnesses for the accused. Now, in those cases, they don't always have signs. They didn't always know. That's a bit of a different issue. But the point is, one of the most difficult things for a young detective or assistant prosecutor in his field to deal with is that the person you would expect the most to protect their daughter, to protect their son, to have a sense of empathy, nurturing, support, to embrace their child who's molested by their man, doesn't. And sadly, sometimes not only doesn't support them or embrace them, but becomes an active and affirmative ally of the suspect and does everything in their power to undermine the division's case or the deputy attorney general's case or the prosecutor's case. From tampering with that child, to not showing up for appointments, to actively testifying on behalf of the defendant, on behalf of the accused, in front of a family court judge or a criminal court judge. But after a while, you begin to understand these people and these moms and these caregivers. I mean, it doesn't make you feel any better about it, but you begin to understand the predicament that they're in. You begin to understand how the non-offending caregiver can make such a bizarre choice to the average person. And this isn't the place to get into all that, but there's a lot of psychology going on there. There's a lot of difficult issues that non-offending caregiver is grappling with. One of which is it's easier to believe that the man that you chose to live with, the one that you devoted your life to, the one that you gave your heart to, the one that you've decided to share a life with is right, and your rebellious 14-year-old daughter is lying and wrong. That is a much more appealing prospect than to believe that the man that you've trusted and loved and lived with and committed yourself to is not only a criminal, not only someone who has broken the law and defied the norms of society, but in the way that is the most repulsive of all, has sexually molested a child, your child, his offspring, or his stepchild. There is arguably no more despicable crime in all of criminal law than the sexual abuse of children, especially your own children. Just ask any prisoner at the county jail or the state prison level. Sex offenders who molest children are nearly universally despised. They don't get along well in prison. They are spat upon and looked at with scorn and disgust by murderers and by, thugs and robbers and crack dealers and the like. So on the scale of humanity, sex offenders are the worst of the worst. Those who prey on children. And those who prey on adults aren't much better, but those who prey on children are the worst of the worst. So you think about it, if you're a mom, and this is your man, isn't it easier to say, you know what, she's wrong, she lies, she smokes pot, I caught her with a boy, why wouldn't she tell me sooner? Why is it not easier, and it is, to rationalize it that way? To rationalize it that way. And I'm not saying I endorse that, and I'm not saying that absolves them from any responsibility, but it helps us understand why they might do that. And it's even more nuanced than that, and we can pick that up in a different class at a different time. So among the persons that fail to report are caregivers. And like I said, once you become a little seasoned, you're not going to go after them. I mean, you know what? This kid's got a hard enough time. If you think about it, you always have to do what's best for the child. And we preach the child first doctrine in the interviewing project that I'm involved with, Finding Words. The child is the most important person, and the case comes second. So if you think about it, and you want to live up to that doctrine, the child first. If you think about it, do you have a plausible basis or a reasonable basis to charge mom? I'm sure you do in many cases. But if you do, then what's left for the child? What's left? You arrest her father, and many times these children don't want their dad to go to jail. They just want the abuse to stop. They just want to be left alone. They just want them to get help. They just want their family to be somewhat normal again. They just don't want to be touched anymore. They just want to make sure that their little sisters and little brothers aren't victimized. They don't tell because they want to see a guy go away in handcuffs. They don't think about the punitive aspects of it. They don't think about the fact that the criminal justice system involves retribution and revenge and just desserts and punishment. That's not what they're thinking about. They just want it to stop. They just want to be left alone. They just want to be able to go to bed at night and not hear footsteps coming in their room. They just want to avoid the terror that they feel night after night waiting for this to happen again. But they don't want to see him go to jail. These dads, stepdads, uncles, not all of them, but many of them are capable of great good. They shower them with affection, they treat them special, they buy them things, they compliment them. Not always, but many of them do. Many positive things happen in these distorted relationships. And many times these kids just want it to stop. Then the system steps in, and we take him away, and he goes to jail, and if he can make bail, he gets out, and he's got to go live somewhere else, and if he can't make bail, He's put an orange jumpsuit. They put a thick brown belt around his waist. There are hooks of thick steel, and they wrap a chain through there, the kind of chain you would use to secure a motorcycle or a bicycle, and a giant padlock, and his arms are tethered at the wrists, and his legs are tethered at the ankles, and they kind of waddle into court. Not a very pleasant sight for a child to see. Very rarely do they see that, but word gets back. Word gets back. So that's the upshot of, that's the consequence of the child telling. And it seems to me to be disrespectful of the child first doctrine to arrest these mothers who don't report, although they knew or should have known. Although they're culpable, although I feel they're responsible, I don't think it helps the child in the long run. Because then what happens? Mom. And you want a child who's going to recant. That's a child who's going to take it back. But that's not why we don't do it. We don't do it because, number one, we begin, as we become experienced in this area of the law, we begin to understand how these mothers think. You know, how they process this, why they choose dad over child. And it's not altogether wrong in some ways. It's certainly not because they want dad to continue to have access to the child. You know, they try to deal with it in their own way. And it's flawed thinking. But these things happen in families, and it's not normal. It's not a normal criminal event. It has all kinds of subtleties and nuances that we can't even begin to appreciate. So the last thing you want to do is go after that person who is culpable, but there are lots of mitigating factors about their behavior. By mitigating, I mean there's lots of things that we need to understand that shows that they aren't really evil or have a guilty mind or really want to hurt their child. They just do it as a psychological reaction to, among other things, to what is happening around them. Things that they never, ever could comprehend. They never, ever thought would happen in their house and under their roof. And the most compelling reason, I think, is, and I said it earlier, is you take away mom in handcuffs, you take away dad in handcuffs, then you're really, really hurting that child. That child doesn't see their mom as, in many cases, as culpable or responsible. Sometimes they do, but even when they do, most of these children don't have much animus or anger towards their mom. Some of them do, but most of them don't. And if they do, not so much so that they want to see mom carted away in handcuffs, you know, and dad's carted away in handcuffs, and there you are, the child, or as the newspapers disgustingly refer to victims of crime now, the accuser. You now become the accuser in your household, and your siblings and the aunts and uncles and all those folks and all the extended family come down on you like a 60-pound sledgehammer. It's not a pretty sight. So arresting moms is not, in my view, the way to go, although you can arrest them on a monthly basis, unfortunately. There are others who might fail to report that might be arrestable, and they work in schools. And if I had a nickel for every principal or guidance counselor or school patrol person who didn't report, and I'm not saying it's all the time, but all too frequent, school systems, if they don't report at all, which is relatively rare, their greatest sin is they don't report right away. They don't report for days, sometimes weeks, while they are conducting their own little internal inquiry. They are more likely to get arrested by someone like me or some other prosecutor who, you know, understands it in the ways that I understand it. And I'm not saying I'm right; others may differ. But again, I don't arrest many principals because, you know, in some ways they are as misguided as the moms. But the right principal in the right case that was educated by us in a prior case, in other words, if you got a principal who did it once and you said, listen, you know, what you did was wrong, you should have reported it right away, you should know better, DYFS had an in-service here, how could you do that? And then a year and a half later, you say, is that Principal Johnson again? You're going to get taken away in handcuffs in my town. Yes.
In cases that are professional only have to report, is the non-offending parent considered a mandated reporter?
No.
So it's only
different.
in
Yeah.
states, only in the all persons states.
Yes, and that's a good question. They're not considered because they're not on the list. However, even in New Jersey, there is the failure to report statute. But because the non-offending caregiver is a caregiver, there is another opportunity to charge them, and that's under the endangering statute. So I don't know what the endangering statute's called in New York, but even a New York mother, you might be able to go after for causing an unnecessary risk to the child. If you leave your child, in 110-degree weather by the pool and go to the theater in the afternoon for a matinee for 6 hours, and the child suffers severe burns or something, that's an act of neglect, right? Not protecting your child from a known abuser could be an act of neglect. So there may be another way to get a mom who doesn't do what's right in those other states. When you expose a child, if we go back to that endangering statute, you'll see that when you expose your child, I think the term is unnecessary risk, then you may be able to go after a mom that way. And we just don't do it. Once in a blue moon, you might go after the mom. Having said that, what we do as prosecutors, and we're going to talk about that in the next module, what we do as prosecutors is when we get a case and we do an investigation and then we make an arrest, the next step in the process, we'll talk about it at length in a little bit, is to go before a grand jury. And the grand jury are 23 people from the community. And they're the lady who works at ShopRite, they're the CPA who works for Anderson Cooper, they're the mail person, they're the average people in your community. They don't live in the world that we live in, and they just sit there and they hear this for the first time. They're not appreciative of or interested in the psychology of the non-offending caregiver and all the subtle dynamics that go into all this kind of stuff that we know. They immediately raise their hand. Well, can we indict the mother? They want to, and then, you know what? And it becomes such a groundswell. And it's usually, when you go before a grand jury, it kind of looks like this, the way you all are sitting. There's tables, rows just like this, and I'm up there, and the detective's there, or the witness, and I ask them questions, and then the detective leaves, and I say, are there any other questions? Can we indict the mother, and what can we indict her for? Yeah, what about that? Yeah, can we charge her with endangering? What about that other? It just becomes this groundswell of anger directed at the non-offending caregiver. And we have a role to do justice in there, and I tell them, I don't get into the detail that we just went through, but I tell them why I think that would be unwise. And sometimes they don't care, and they charge anyway, and we wind up with an indictment. So when you say, Tyson, you've never heard of one, I'm sure you haven't, and I don't know that I've ever done it in 15 years. But the grand jurors have done it, and we've had, and you can't tell them no. You can recommend, but if they indict, they indict. And I'd say over the years we've had about 15 or 20 where the moms got indicted despite. Now there may be ones where we go, hey, go for it, where you felt that way and you were on the fence, and then the grand jury wants to indict her or him. It's usually a her. You don't even recommend anything. Okay, you have that right, jurors. That's within your province. I will instruct you on the law. If there is an unnecessary risk, if failure, you tell them what the law is, they vote. It only has to be a simple majority. So there are cases, more than a few, I'm saying 10 or 15 in 15 years, where they indict the mother. We in law enforcement don't charge the mother, but the grand jury charges her in a formal accusation called an indictment. And that happens once in a blue moon. And then we deal with it, and you try to get the mother. Sometimes the mother who knows is also a witness for us, right? And you got to go to court, and very often you don't have much evidence, and you've got that mama who knows, and, she heard him, she went looking for him once, and he was in her bedroom, we're watching cartoons at 4 a.m. You want that testimony as a prosecutor. So you try to make a deal with her and do that kind of thing. But, yeah, grand jurors typically bring this up. In the case I mentioned a little while ago, in a different case, I can't talk about grand jury cases and what happens in there. I can talk generically. In a case I had recently that involved many victims, the grand jurors were very, very adamant about charging the mother. And because it involved intergenerational, it wasn't intergenerational, but because it involved many girls, many children in that household, and then a subsequent child in that household, the grand jurors were like, we want to charge her. And I had to be a little more involved in explaining why I didn't think that was a good idea. And quite frankly, when I first spoke to the two main women who had contacted me, and they live out of state somewhere, and they told me about this case, they said, we did report it to you in 2004, but then we stopped cooperating. But now we want to cooperate, and we're starting to really deal with this, and we want to take the next step. I said to them, well, look, I'll do it, but you have to make a commitment to me. I'm not playing games. You got me on the phone now. They had a detective a few years ago. And, the right thing happened. But I said, look, you're talking to me now, and you think about it. I don't want, you called me and you want to do it, but I want to make sure you really want to do it. I want you to call me on Monday or Tuesday. I want you to think about it. And then when you call me, you have to say to me, Joe, we're with you, all of us, through the end, no matter what happens. Much like that Capo case I described to you earlier. We went to the Appellate Division of the Supreme Court. We got a mistrial. I described that a couple of weeks back. You have to let me know that you are committed. I don't want to be filing motions, preparing a case, and 6 months from now you start to feel bad or you start to have mixed emotions. You have to make a commitment to me that you're going to see this to the end. And when's the end? 2010 maybe? Maybe 2008. I don't know. The more you show unity, the more you show you're behind me, the more the whole family is on our side, and you show cohesion, the more likely it is we'll resolve this earlier. Any cracks in that cohesion make it more likely that the accused will want to roll the dice and have a trial. You make a commitment to me, I'll make a commitment to you to prosecute it to my best ability. And they called back and they made that commitment. But one thing they said to me was, we don't want our mother charged. These women were astute enough to realize that their mother was vulnerable because their mama knew or had reason to know over the years. And the one thing they were emphatic about was, please, we'll make a commitment to you. We don't want to see our mama get in trouble. And I had kind of forgotten about that. That was a couple of months went by, and I go to grand jury. I have to go with the X case to court. And I go to the X case to grand jury. And then the grand jurors start saying that, and it started ringing in my head what the women were telling me. So I really had to educate those grand jurors and discourage them from indicting Mom. But it wasn't easy, because Mom really was foolish, as they often are. Can someone tell me who inspired mandatory reporting in the United States of America and what year that was? I don't ask these kind of questions. When was the Battle of Hastings, 1066? When was, when did Leif Erikson come to America? But this is a landmark in child protection this year. And if you know, it'd just be fun if you remember. More importantly is, who was the physician who wrote the landmark paper in this field? Or what was the paper? Kempe. Yes. He was a physician. He was a doctor. Kempe. And what year? 1962. Excellent. In 1962, Kempe wrote the article, The Battered Child. The Battered Child. And it was about how abuse happens within the household. And that it is a public health epidemic. And law enforcement and social work and psychology and professionals aren't doing enough, if anything, to deal with this public health problem. And that led to, in a few short years, the mandatory reporting statutes. We see it, we ought to tell the system, and the systems ought to be able to respond. And it swept the country till eventually every state had and has mandatory reporting. And one of the articles that you read and made some observations about, which was surprising to me as I began preparing for this class, I never knew this. And that's why I included this article among your readings. I never included it before. And what am I talking about? Our friends across the pond, England does not even have a mandatory reporting statute. Nor does Ireland, I believe. And perhaps Wales, all of the British Isle and the Empire of Great Britain. No mandatory reporting. Now they're beginning to consider that. They're looking at a lot of different options. There were some interesting observations on the discussion board about that, about the kinds of things that go into a registry-like process. I don't think the issue has been completely fleshed out in England, but you could see that they're struggling with it. They tend to think that they're different, that England has a institutional structure that doesn't need mandatory reporting, that their professionals are better educated or more involved, or they are more socialized, that their systems are more socialized and better able to highlight these things or identify these things if they happen. But there is another group of opinion that says maybe it's time that England, in 2008, in 2007, ought to have mandatory reporting. If you make a report, if you're a guy walking down the street, or you're a psychiatrist trained at the University of Chicago, and you fail to report, you are certainly potentially liable for failure to report. We just discussed that. On the other hand, if you do report and you're wrong, can you get in trouble? There is an immunity provision. If you report a reasonable suspicion of child abuse and you're wrong, you have immunity. Immunity from civil liability. That is, you can't be sued for money damages. You can't be sued in civil court for money damages because you were wrong. Okay? However, the report must be in good faith. And that could be a source of litigation. You can't just make stuff up. You have to have a reasonable suspicion. And the courts are very, very forgiving. They take a very liberal interpretation of what a reasonable suspicion is. Why do you think they passed that law? At the same time they passed these other laws. Nadia? I see a spark of an answer there. Maybe my glasses aren't on. Why would you want to tell reporters, listen, we want you to report, and if you mess up, don't worry, you can't get in trouble. Why would we tell them that?
I guess because that's a lot of people's fears, that they don't want to say something and then they're wrong,
Therefore they
don't say.
So therefore they don't say anything. That gives them some comfort that they can't get in trouble if they're wrong. And that's what a lot of people worry about, right? You read teachers, do they report? That article that I gave you? Mandatory reporters, do teachers follow the law? And do they always? No. What are some of the reasons that teachers, or even professionals like psychologists, don't follow the law? Africasia?
They may feel like they're going to cause a conflict with their parents or the students. Well, you mean as far as teachers?
Teachers,
They feel
yes.
uncomfortable. They don't want to cause conflict between the parents. They might have good rapport with the parents. They just feel uncomfortable.
They feel uncomfortable. They don't want to cause conflict within the family. And they're not sure. It's a little bit of that, too, because if you really knew it was true, you would hope that they don't care about conflict. So it's complex. They're not so sure. They're kind of sure, but they don't want to cause conflict within the family. Okay? And that's related to some other issue, too. They feel they might do more.
Damage in a lot of ways. Are they only teachers?
No, Africasia taught in a charter school, right?
Like when you, like I was going to ask how in like counseling, like how if you're with a psychologist and you admit, how do you balance the doctor-patient confidentiality if you're counseling someone and they admit, like, then you have to go to the cops, but like teachers have a lot of that relationship too.
Mm-hmm.
And in schools are there is no confidentiality in a school truly, because you know where we're on set schedules like Pavlov's dog. The bell rings, we go to our next class. So when people are missing or if cops show up in the building, it gets around. So it becomes, well, you can't say anything to that teacher because he'll report it, and it's that fine line, because if students don't feel comfortable with you, you're never going to learn anything to help them. But at the same time, once kids don't trust you, it's a very fine line. I mean, I reported a kid once on suspicion of drugs because his grades went down. His eyes were all bloodshot and red. He had every classic symptom. So I sent him for a drug test, which was anonymous. He was completely clean. What nobody knew is his mother was in the hospital dying of cancer. He was spending every night with her. But because everything matched that, I felt terrible for that kid. And he comes to me complaining because the vice principal sent him. And I'm the one that sent him. I felt terrible, but I knew I'd done it for the right reasons. But if that kid ever found out that I did it, he would never trust me again. And that's so much in a classroom in any school.
There must have been other signs, though. Did you call the student in and talk to him and inquire a little bit?
All of a sudden he was absent all the time. This was going back almost 10 years ago. But all of a sudden he was absent a lot. He wasn't doing any of his work. His grades were dropping. Bloodshot eyes, sleeping in class. I'm trying to think if there was anything else at the time. Just his personality was changing.
Right.
He wasn't as outgoing. So on the surface, he had every sign.
Right, sure.
And he wasn't sharing anything. So, what do? You ask the kid's friends, what's up with whatever, I don't remember what the kid's name was now. You'd say, well, what's up with it? I don't know. He's just, he's not around anymore. He's not hanging out. So you take everything. You ask, the other teachers, they're seeing it. So what else choice do you have? I have a reasonable suspicion now over 6-8 weeks.
Yeah.
But you do something that impacts further. It's a very fine line. You walk in schools are. There is no real true confidentiality in a school.
And you put your finger on a very important distinction between social work and psychology and medicine, in that there is a very pronounced relationship of trust between students and teachers, yet it is not protected by law. It is not protected by statutes or administrative regulations governing confidentiality. In fact, as you point out, the opposite. There are a myriad of obligations for you to report a variety of different behaviors so that kids' well-being is protected, children's well-being is protected. Nevertheless, you still need to maintain a good rapport and a relationship of trust with a child, or else your role as an educator, your ability to teach, is compromised. So you have to balance all of that, and you don't even have statutes that you can rely upon to protect confidentiality.
There's very simple things like, I'm a male teacher. I'm very, like, a girl can walk in my classroom, violate dress code, I don't care. I won't address it. I don't feel comfortable. It's just not something, and my administration knows this. But I won't like meeting with kids in private. If there's an issue you need to discuss, we're never supposed to be in a classroom or in a private conversation. So how do you, like, a lot of teachers won't deal with it because they're, you don't want anybody to think, you're in a classroom with somebody. Well, then the kid's like, why don't you trust me? And it's a very, you're dealing with teenagers who don't always think, logically, and don't think. So there's a very delicate balance in people's, careers. You make one mistake, and it may not cost you your job, but it can make your career very difficult on a day in and day out basis, especially if you work in small towns or small schools.
And back to the original question, that's why many teachers find it difficult to make that report, because among a variety of issues, one of them is they think that they're going to do more harm than good. So they require, in their minds, more than reasonable suspicion. They require a pretty good belief that something happened. And a reasonable suspicion is a lower standard than a pretty good belief, and I just made that standard up. But they want to be really firmly convinced that something is awry, because if they're wrong, they may not be able to be sued, but their reputation and their standing and their relationship with this student and future students can be compromised, and thus their effectiveness as an educator is diminished for many years, and it's hard to shake that. So it is a difficult challenge, and that's why that article addressed some of those issues. I think they examined the Kansas school system about 10 years ago, yeah.
I had mentioned it once on the discussion board.
Yes.
There was a case that, not a case, but a co-worker's child goes to school with this other kid who was clearly telling counselors, and I'm not sure if she told other people, that her mother was abusing her. But I guess the counselor figured, oh, this kid's such a troublemaker, and there was apparently no evidence, like physical evidence that anybody could see that she was actually being abused. So I guess they figured, oh, we don't have to say anything because, you know, there's no other evidence except for her just saying it. So I guess my question is, if a kid that, let's say they're a pathological liar and you know that they have a history of just, you know, starting rumors and whatnot, and you know that maybe they have an agenda against their mom because maybe their mom got remarried or something like that, is the fact that they said it enough to say, oh, there was reasonable suspicion and you ignored it, like for that counselor?
Well, that's an excellent question, and that kind of intellectual analysis happens all the time in schools. Nevertheless, our message, when I say ours, the child maltreatment community's message to teachers is, and to principals, and to medical professionals, and to anybody else, is in that case, it's a bit of a no-brainer because there's an explicit statement of molestation, and your job is not to evaluate the credibility or believability or likelihood of it being accurate or not. That's the job of the trained professionals from the division and from law enforcement and from prosecutors' offices and the like. Once you get into that, then it becomes your subjective analysis. You become the judge, the jury, and the investigator, so to speak. And that's not the role of the teacher. The teacher or the medical professional or the social worker, if there is a clear description or statement or evidence that's clear, you have to report. It's not even close. When there is a vague belief that something might be going on, then that reasonable suspicion analysis triggers in, and you have to evaluate it the best you can. And we recommend, when I say we, I recommend, and my staff, it's better to be cautious. You know, DYFS gets a bad rap sometimes because they are accused of overreacting to child abuse, that they're over-involved, that they over-respond. And they are also subject to criticism because they under-respond, and they don't respond enough, and they don't go out enough. And, you know, if you get enough of that in balance, you're doing a good job, you know, because, you know, you can't have it both ways. You can't be a system that doesn't respond enough and then responds too much. They don't need cases that have no merit. So just because you may report a case that is borderline reasonable suspicion, whatever that means, just because you report a case that's borderline suspicion, reasonable suspicion, you know, doesn't mean that the division is going to, or law enforcement is going to, you know, prop that up into something that it isn't. We have enough work, enough cases, and the very things that give teachers a lack of confidence in whether this is really abuse or neglect are the same things we would look at. The problem is sometimes the things that teachers or professionals or social workers and the like might look at as indicative of a lack of credibility or evidence that this is not a reasonable suspicion case, this is not a credible accusation of abuse or neglect. Those kinds of signs may be not persuasive. They may not be legitimate signs, because a girl who's a pathological liar, a girl who is the most promiscuous girl on campus, the girl who is manipulative, the girl who's angry and in a gang, who's tatted and pierced and just the kind that really, you want to stay away from. She's never got something positive. All that anger, all that rebellion might be very much a symptom of her exploitation. Those kind of girls, and it's boys too. And some of the most angriest child abuse victims I've ever met are the boys. Just so much internalized anger. And we talk about girls a lot because they predominate, but it's the boys who are exploited or molested by their dads or their dad's friends, or by male authority figures. I'm not sure there's anyone angrier on the planet who acts out more. But in any event, whether it's a boy or a girl, that kind of acting out, that kind of just unpleasantness, to use an understatement, that are exhibited by these kids that you just don't want to believe may be very much the child who was molested. And it needs to be looked into. So if there's a clear statement by the most obnoxious, unbelievable, manipulative, scary, delinquent girl on campus, that's the one you want to take as close a look at as anybody else. And that child may very well be. I often say to juries, or a version of this, because you can't get too instructive in front of a jury in a summation, but I try to imply, or I try to make it clear that there's a simple truth. 14-year-old girls, 13-year-old girls, 15-year-old girls, they're not born to be that vicious and that manipulative. They're not born to be that promiscuous and that indiscriminate in their sexual liaisons. That's not how God or nature or nurture has programmed people, much less young women. They may make a host of poor decisions, but to be that promiscuous, that angry, to be that rebellious, you're not born that way. Somebody made you that way. Something made you that way. And I'm not saying there aren't young women who are sexually active as 14 or 15 who aren't victims. There are. But when it reaches that kind of behavior that's pathological, that's scary, that's over the top, that is mind-boggling, that shows a total lack of judgment and discrimination, and a total lack of self-respect for your body, for your boundaries, for your womanhood, for your very person, that's somebody that you might want to look at and say, geez, how'd she get there at 13? And guess what? She wasn't born that way. Somebody made her that way. And that's the challenge, is to find out what circumstance created that child. She's only been on the planet 13 years. So something's going on that we need to find out about. So that's why I say, you know what? Don't be in the business of evaluating, well, this kid, she lies and cheats and she's a mess. It's the last person I would believe. She lies for her entire tenure in high school or whatever. Sometimes the worst children are the most psychologically fractured, and they are the most likely to be living in a household that is defined by dysfunction, by violence, and sexual molestation. Yeah.
Well, that's exactly what happened in that case, because my coworker found out about it because her kid came home.
Where do you work?
I'm at Emerson.
Oh, okay, go ahead.
And her kid came home complaining that this other girl had been acting out against others, and even my coworker's child knew that the girl had been telling people that she was abused. Now, the fact that my coworker's kids, and a bunch of other mothers were called in to have like a meeting about what to do about this kid, and nobody called to report it to anybody, is like completely ridiculous. Like, they tried to figure it out, like you said, amongst themselves, and become the jury and the prosecutor, everything. And not even the principal knew. They figured they'd try to figure it out with, like, among themselves before bringing it to like a higher authority. And it's ridiculous. And I told my coworker that there probably is something going on at home. It's probably not just a girl lying about, because why would she do that?
Mm-hmm. Having said what I just said, rather emphatically and a little passionately, I will also tell you in great candor that when DYFS or we in law enforcement get these kids, we understand them, but they are not top of the pops with us either. And not because we don't appreciate that they may be a victim of a terrible upbringing or a household marred by violence, but because there's those same kind of credibility problems that your coworkers feel, juries feel, judges feel. The system has a hard time embracing these fractured kids. I say that it ought to be reported because, nevertheless, we'll go out, and guess what? 1 out of 5 of them, the bad guy confesses, or you find a sibling who was molested, or the mom tells you something. So just because in and of themselves, it's unlikely that they'll ever have the credibility, because they are so rebellious and so troubled, to carry the ball on their own, to convince even a family court judge by a preponderance of the evidence, 51%, by at least taking a peek behind the curtains of that household, you may find evidence that helps that kid be believed. So I believe we need to take a look at even those kids. Because number one, they are more likely to be victims in many ways. And number two, once in a blue moon, you find that kind of corroboration that you can win the day with those kids. Unfortunately, a lot of them, all we're left with are those kids, and the family system rejects them. The criminal system rejects them. And you have to say to yourself, did we do more harm than good? And I think in the final analysis, we do more good than harm, because you take a shot. But when they are brought through the system, and the system offers no help, they are more entrenched and more rebellious and more unhappy than they ever were before, because now the very system that rejected, that took them in and gave them a smidgen of hope, even though they may not have seen it that way, has rejected them, and their self-esteem is even worse than it ever was. And those are the saddest things we do, unfortunately. But I think it's incumbent upon us to take a shot anyway to try to help these kids. Those kids become even more troubled along the way. And then you get them back again sometimes, and you'll never get anything from them. Was the issue of whether mandated reporters report. One of the articles you read was about teachers, and that article examines in great detail, and you will be responsible for some of the issues that are raised in that article about whether teachers report. You will be responsible for some of the reasons why they don't report. And we talked a little bit about the issues that are raised in that article. They think they may do more harm than good. They're not too sure whether something happened. They're not too confident about just what rises to a reasonable suspicion. They don't want to break or breach trust between themselves and the child in the future. And there are a number of other issues. It's not only teachers who encounter these kinds of ethical quandaries. It also might be a therapist or a hospital emergency room physician that learns about suspected child abuse who may be reluctant to report it. If a therapist has information that a child has been or is being abused, can they withhold that information under psychologist-patient privilege or social worker-client privilege or any of the ethical or legal privileges that govern special relationships between professionals and clients? Can a professional rely upon confidentiality in not reporting child maltreatment? What's the answer? No. The answer is no, that the obligation to report suspected child maltreatment abrogates or trumps or overrides confidentiality in every facet of it. Whether you're an attorney or a doctor or a psychologist or even a psychiatrist, whatever your discipline, whatever your profession, however confidential that relationship, you have a duty to report same. Even a clergyman, a rabbi, an imam, some religious person, although they may have very strict rules about confidentiality, the mandatory reporting statute overrides confidentiality. We talked about civil liability. That is, if you are aware of child maltreatment and you don't report, you can be held criminally liable. It's really what we call a disorderly persons offense. You also might be held civilly liable if you don't report. That is, you might be subject to a lawsuit. This is the opposite of reporting and making an honest mistake. If you are aware and don't report, you could be charged quasi-criminally. You can also be held civilly responsible, for negligence or recklessness, negligence, and may have to pay civil damages if a child gets molested again or injured again. There is always the potential for civil liability. That is, a professional may be financially liable if a child suffers further abuse. There may be administrative liability. That is, if you're a licensed psychologist or licensed clinical social worker, you could suffer administrative liability for failing to report. Your license might be impacted. It could be suspended. Or you might be expelled from the profession. So there are consequences beyond a disorderly persons offense for failing to report child abuse if you are a professional. Some states even have a legal presumption of good faith when you report suspected child maltreatment. A legal presumption of good faith. We're going to take a look at a number of cases from the New Jersey courts, mostly the New Jersey Supreme Court, that had the effect of leveling the playing field for children in the legal system in the early 1990s. It was a very exciting time for child maltreatment professionals during the period from 1990 to, say, 1996, especially for legal professionals, persons who were involved with children in the legal system. The rules of the game changed quite dramatically at times, and mostly for the benefit of children. And the cases that we're going to look at today had the effect of leveling the playing field and making the courts a more fair place for children and somewhat friendlier for children within the courts, within the legal system. And a lot of the cases that you read for today, KAW, RW, DRH, a lot of these opinions of the New Jersey courts, Crandall especially, involved the Sixth Amendment of the Constitution. So to have an appreciation of the Sixth Amendment and a working knowledge of it, I think is critical to appreciate and understand all of those cases that we're going to talk about in the last half of today's class, because the Sixth Amendment is operative in nearly every one of them. Let's take a look at the statute itself. In all criminal prosecutions, the accused, it's not the statute, we'll look at the Sixth Amendment right itself. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. A lot of critical procedural rights in that one amendment. First of all, you got a right to a speedy trial. But more importantly, you have the right to a jury trial in the town and district where the crime was committed. So that the notion that you have a right to a trial by a jury of your peers is better effectuated. Right? You want to have a trial where the crime was committed. You have a right to be told what the crime is. They didn't always do that in England. They hauled you off to the Star Chamber or to some other such place, and at times you didn't even know what crime you were accused of. And as I discussed earlier, one of the most critical aspects of the Sixth Amendment, you have a right to be confronted with the witnesses against you. You know, I was watching a biography of Leonardo da Vinci on PBS or Discovery Channel or History Channel, and I enjoy those shows. And when Da Vinci was a young man, he was brought in for questioning and nearly charged if he wasn't charged. And I don't know if the offense was buggery or homosexuality or something like that, which was in Italy during that time period under Florentine law, an offense. But what was bizarre about it was he was charged in almost a suggestion box. You could go at night and stick an accusation of a crime in a box in a town square anonymously, and you'd be hauled in for questioning. And here was Da Vinci. I think he may have been 19. It was before he was famous and respected, who almost had his great potential quashed by an accusation that occurred anonymously in some town square accusation box. In any event, the Sixth Amendment tolerates no such thing. You have the right to confront the witnesses against you. And also, something that people don't really pay a lot of attention to, you have subpoena power. You have subpoena power. That's that compulsory process part. That means not only can you confront the witnesses against you, but you can have a subpoena issued and force people under the authority of the court and the law to show up in court if they have evidence favorable to you. Very important part of the Sixth Amendment that a lot of people forget about. But for our purposes, I want to focus more on the section that deals with confronting the witnesses against you. Now, the next clip I want to show you involves, I believe it was the third wife of Henry VIII. No, it was Henry VIII's second wife, Anne Boleyn. The court in England of Henry VIII is among the most fascinating. I find it very interesting. Certainly the public does. There are a number of different movies and films and dramatizations. There's a film coming out right now with some major actors called The Other Boleyn Girl, with Scarlett Johansson and a couple of other grade A celebrities. I'm looking forward to seeing that. We'll see how well they do that film. I saw the original Elizabeth from 1999 with Cate Blanchett. I'm in the middle of watching Elizabeth the Golden Era. Elizabeth, interestingly, was Henry VIII's daughter. Henry VIII's passion, Henry VIII's obsession was to have a male heir to the throne. And he only had one male heir. And he died when he was 15 or 16 after Henry VIII died. But he was the father of quite a few female children. And the irony is, in his quest, his obsession to have a male heir to rule England so that the line of his family was maintained as the monarch of England, and he didn't have a male heir, at least one who had a meaningful reign. The irony is he had a female heir who is among the most famous, the most celebrated, the most respected queens who ever lived, Queen Elizabeth. So for all his obsession with having a boy child to be king, he had a girl child who he really was totally disappointed in, who became one of the greatest monarchs in all of English history, Queen Elizabeth, the Virgin Queen. This clip is not about Queen Elizabeth, it's about Anne Boleyn. And Anne Boleyn is a fascinating character in English history. You see, King Henry, when he ascended to the throne in his late teens, I believe it was, when his father died, he married his older brother, who predeceased him. He married his widow. So Henry VIII married his sister-in-law. And I think she may have been Catherine of Aragon. She was a Spanish princess. And he married her and stayed with her for about 15 years. He had many mistresses on the side. And one mistress was a lady in waiting, a beautiful woman of court, Anne Boleyn. But Anne Boleyn had great aspirations. She wanted to be the Queen of England, not the mere mistress of the king. And while King Henry could bed down and have sexual relations with any woman in the entire kingdom, the one that he wanted, the one that he desired more than anybody was Anne Boleyn. But Anne Boleyn would not sleep with Henry until he divorced Catherine of Aragon. He tried his best, but Anne Boleyn stood firm. And that only made him more passionate, more zealous in his desire to bed Anne Boleyn. So he goes to the Pope through his intermediaries, the cardinals who advised him in England, and said, I need an annulment because I need to marry Anne Boleyn. I want this woman that bad. And the Pope, for political reasons and other reasons during that time period, refused to give an annulment. Henry's argument was that there was fraud involved in the marriage to Catherine of Aragon, who became the mother of Mary, who was the queen before Elizabeth. But in any event, he wanted this Anne Boleyn really bad. And finally, he decides, and some of you may know this and some of you may not, he decides that because the Pope won't give him a divorce or an annulment, and because he has to have Anne Boleyn, England will secede from the Roman Catholic Church. And he declares himself the head of the Church of England. They break free from Roman control, and now the Church of England is ruled by the king himself. And at that time, there was a lot of conflict between Protestant sects in England and Roman Catholic sects as well. So some of the people embraced this as a Protestant act, and Elizabeth herself was a Protestant, while her sister and the daughter of Catherine of Aragon was a Catholic. Very interesting religious dynamics going on there. But in any event, the whole source, in large part, because that's kind of inconsistent, but in large part, the reason why we have the Anglican Church is because Henry VIII couldn't have sex with Anne Boleyn. If she had given in to his desires, England would still be Roman Catholic. At least it's arguable. But it didn't turn out that way. So there's a schism. Henry VIII breaks free from the Roman Catholic Church, declares himself the head of the Anglican Church, and he gave himself an annulment. And that was the end of Catherine of Aragon. And he marries Anne Boleyn. After a while, things get tedious with Anne Boleyn. He takes many mistresses, as he did throughout his marriage to Catherine of Aragon. Anne Boleyn is as feisty, is as intelligent, as strong-willed as any woman who was ever in the court, any woman who was ever in the kingdom. She wasn't tolerating his fooling around. She would confront him from time to time. Real headstrong woman. Eventually, she was accused of being a traitor. And she was hauled off for a criminal trial. And she was charged with two things that were considered treason if you were the wife or the Queen of England. One act of treason was adultery. She was accused of having sexual relations with a person other than her husband, which is a capital offense in England at the time. It means you get the death penalty. The other offense was incest with her own brother. Both charges, the incest was patently false. Most scholars find that to be completely untrue. And many scholars believe that Anne Boleyn was faithful and never cheated on Henry VIII at all. These allegations were pragmatic and designed so Henry could be rid of Anne Boleyn and marry the next pretty girl who captured his fantasy at court, and I believe that was Jane Seymour. Jane Seymour. Not the movie actress who took her name from Jane Seymour, but Jane Seymour, the third wife of Henry VIII. And I think Jane Seymour may have given him the male heir. She wasn't beheaded, Jane Seymour. She died eventually from childbirth, I believe. I may have gotten it a little bit wrong. But this is a clip from a dramatization of Anne Boleyn's trial. And you can see, I'm going to ask you, where the Sixth Amendment is implicated in this trial clip. You will tell me how the Sixth Amendment is implicated here.
It's a sad day when the nobility of a country does not stand for its queen. You decided when that same queen is charged with adultery and incest.
Is charged is different from convicted, Master Cromwell. Or is it not in this court?
Charge is that between the 24th and 27th year of the reign of our sovereign Lord Henry, King of England, his wife, the Queen, having been seduced by the devil, did knowingly commit adultery.
How do you plead?
Not guilty, my lord. Further, as Queen, I challenge the right for this court to try me at all.
On what grounds?
They are not my equals.
I caution Her Majesty against such arrogance. We have a mountain of evidence against her.
Correction. A mountain of lies.
I have countless statements from witnesses sworn under oath.
Well, then either these people have perjured themselves, or you obtained your statements with the Brackenians.
Does the Queen presume to call me a liar?
Greater justification than you call me whore.
My lord, why do you tolerate such disrespect? I have here 100 pages of confession that show the Queen has committed fornication, high treason, and matters of a sexual nature so offensive to God.
Well, then can we not read these statements? And where are these witnesses? Are they not present so we can hear them for ourselves?
They're condemned. We will not insult His Majesty by admitting their evidence in his court.
Why not? You insult him far more with the perversion of justice that is happening here in his name.
I hardly think this Queen is qualified to speak of perversion.
Silence.
My noble lords, if what I fear is true, namely that you have condemned me already, well then my testimony is of no value. But allow me, for the sake of the record and my conscience, to say this. The love I have for my brother is the love any sister would have for someone with whom she's grown up, nursed when sickly gazed as a child. And that is the love I have for her. As for these other gentlemen, I have no more been their lover than I would lie on my own daughter's life. I admit that I have not always borne towards the king the humility that is fitting. I admit that I have been jealous. And I admit that I failed to provide him with a son. But it's God is my witness. I have not betrayed him in any other way. That is my word. You must put it to your consciences.
My lords, the time has come to cast your votes.
Guilty.
Guilty. Guilty. Guilty. Guilty. Guilty. Guilty. Guilty. In which case the burden falls on me to pass sentence. Anne, Queen of England, you have been found guilty of treason by this court. It is therefore my duty to sentence you to be burned or beheaded at the King's pleasure.
Well, the king showed some mercy because he had her beheaded and not burned. So what was the... I think I'd rather hit you over the head in that clip, huh? What was the Sixth Amendment issue? Very good. Tried by her peers, and clearly she wasn't tried by her peers, according to her. Ken? To confront the witnesses. That was they had a stack of confessions. She even challenges it.
I was going to say to hear the accusations. She kept saying she wanted to hear what they actually said.
Right. They were vague accusations of adultery and incest, but the specifics of them were not provided to her. Not represented by counsel, another Sixth Amendment issue. No attorney, no legal counsel, no legal advice.
She had a response to the charges.
That's the Fifth Amendment, but that's a good point too. There's Fifth Amendment implications. She had to give an accounting. She was forced to give an accounting to provide a defense, which she wouldn't have to do. But that's an excellent point. That's a Fifth Amendment issue. She didn't seem to have, and maybe someone bring this up, she didn't seem to have any subpoena power, to use compulsory service. She didn't seem to have any witnesses for her.
I don't know if this makes sense, but if there was no deliberation by the jury, I don't know if that's covered up in the circular. So they just kind of, they didn't.
Yeah, well, you have a right to a jury trial. It seemed to be not quite a jury trial at all. I mean, arguably they thought about it for a moment and deliberated, but deliberations can be for a second, I guess. But there didn't seem to be any meaningful deliberations, which was unfair. I don't know how much that's implied in the Sixth Amendment, but there are two favorite parts I have in there, and I've seen it a few times, so it's a little subtle. But when she makes a comment how they treated her, it's a sad day when the nobility treats their queen like whatever, a commoner or whatever she says. And Cromwell gives her a little obnoxious response. But finally, they all begrudgingly stand up. Oh, that's what she says. In this court, are people guilty before they're convicted? And there was a point to be made there, though, because that was the presumption of innocence, too. She was speaking of the presumption of innocence. And she said something like, as I understand the law, you are presumed innocent until convicted. Or is that not the issue here? And it's a sad day when the nobility of England treat me not as a queen. And what she meant by that was, you're disrespecting me. She walks into the room in all her regal splendor, and these men just sit there. They're supposed to rise when the queen enters the room. Then eventually, they really had no argument to that. She made a very persuasive legal argument. I'm innocent right now, and I am still the queen. Yet you sit there in total disrespect. And then, will the men rise until she's convicted, and then it doesn't really matter. And the other thing, she challenges jurisdiction and the jury of peers, too. She says, you are not my equal. And she says it in such a delightful way, I think. But certainly didn't help her avoid the... And I tell you what, they didn't use the guillotine in England. Now, the guillotine was first utilized in France, and it was used to great effect during the days that followed the French Revolution by Robespierre and the other persons who had ruled post-revolutionary France. And it's often said that the guillotine was designed to be a humane way to execute someone by beheading. What does it sound like? What's that? But in England, they brought an axeman and an axeman committed to beheading, which was certainly favorable to the burning. KAW. Let's go back to the U.S. in the 1990s and take a look at the KAW case. And this is about what part of the Sixth Amendment, something Anne Boleyn kind of mentioned and you guys mentioned, what was the issue that the defendant, the accused, in state in the interest of KAW, brought up about the Sixth Amendment? Yeah, there's elements of that, the charges that are brought against him. And it was brought up in the context of not knowing the dates that these alleged offenses took place. The difficulty is, in child abuse cases, very often the abuse is chronic. That is, it happens over and over again. And in nearly every case, there is what we call delayed disclosure. That is, the child doesn't tell right away. They tolerate chronic sexual molestation. And then sometime later, they tell about it. So, it concluded in the past, or if it's still going on, it started some time ago. And it is very difficult for children to express when something happened, when some sexual acts occurred, when it's long-term and you can't separate discrete or singular acts. Each act kind of melts into the other. So it's hard to put a date on any particular act. You see, when something happens over and over again, it's difficult to identify and isolate a single act, especially if it happens in the same place. So it's hard to put dates on chronic victimization. The other thing is, since it happens in the past and children are not good at, developmentally, children find it difficult to express things chronologically or to express accurately the time that something happened. There's a tremendous disadvantage for children if they are required to provide the date of the offense with precision to the defendant. On the other hand, the defendant has a right to notice. He has a right to know what the charges are. And by knowing what the charges are, you have a right to know when they occurred. That's part and parcel of this Sixth Amendment right. 14th Amendment, too, is involved. So what did the court decide? Did the court decide that in child sexual abuse cases that the victim has to provide a precise date that the assault occurred? Or did they decide something else? Nikita?
Yes.
What did the court...
I was so busy writing. I'm sorry. Repeat that.
Well, I was asking was, does the court require that a child give the precise date that they were molested? Or does the court give them some leeway?
In even article, I don't know that they ask for specific dates. Maybe I'm just sure that
Well, the point of the case is that while in your average crime, if you were burglarized or if you were mugged, you have to provide the date that it happened. It's expected. It's not a constitutional requirement, but it's related to a constitutional requirement. You have to provide the date to give notice to the defendant, who might have an alibi or might need to gather evidence about what was going on in his life at or around the time that he's accused of something happening. it is important. It's an important part of notice to know when something happened. I can't say, well, Chuck stole something from my briefcase. When? I'm not telling you. A while ago. Some time ago. Well, that's not notice. You need to be specific. You need to give me something more than that. Did the court say that children have to provide a precise date of when something happened? Kirsten?
When you say it has to be within a period, a certain period of time, not specific.
The court permitted that it permitted the prosecutor, and thus the child, to charge an offense as having occurred within a particular range of time. Now that range of time has to be narrowed as much as possible. And what are some of the things the court said to try to anchor the molest in time for the child? Daniela?
The kid would understand, like, the change of seasons, or maybe like a big event, like let's say like a birthday party or something that only happens on specific days, or when somebody was in town and they knew that they were around, or just like a specific presence of a person's or presence of an event rather than an actual date, like the 7th of September.
Excellent. Chuck?
That's what I was thinking, just like around the holidays or something, so they have a general like time frame or window of when it likely happened.
Right. We had a case 2 weeks ago where these girls were fondled in a shed in the back of someone's home in Patterson. And nobody raised the issue, but I learned that it happened when their aunt was visiting last year from Colombia or somewhere in South America. And I said, well, you know what? Let's find out when she was here. And we wound up getting a copy of her visa. And now we know that she was there at a particular time. We anchored it in a known event. That's what you want to do. You want to connect the child's experience up to a known event. A birthday, a visit from an aunt, maybe when we lived in the house on Norfolk Street, and they may have lived there for a year. At least it narrows it down. Well, was it the summer you lived on Norfolk Street? Were you in school when you lived on Norfolk Street? You want to try to narrow it down. We don't ask kids for dates. We ask them for landmark events or meaningful events in their lives that we can connect up to the calendar indirectly. I had a case once where the child remembered what bike she had. And that's a good way to, when I was growing up, I had a series of bicycles. Like we have series of cars. If you remember something, if you were an adult, and you were trying to remember something that happened some years ago, you might say, well, what car were you driving back then? That's when I had the Honda Accord or the BMW 3. I remember that. I had that from 99 to 01. It was a lease. And this little girl, in my case, she went through a series of bicycles, and she knew that it was this particular bike with the banana seat that Grandpa gave her. And her mother knew she only had that bike for this amount of time. So we were able to connect it to the bike, which connected it to the calendar. Right? So that's what KAW is about and how the Sixth Amendment is implicated. State versus Crandall is a pure Sixth Amendment case. State versus Crandall is the closed circuit television case. Can someone tell me why State versus Crandall is a pure Sixth Amendment case? The closed circuit television case. Application?
Because it involves the right, it's discussing not the right, the right to confront your,
It is a right. It's a right.
confront the witnesses, confront the person accusing you.
The right to confront the person accusing you. How does Crandall involve the right to confront the person accusing you? What about what does Crandall have to do with that right?
Because the child is not directly in the room with the defendant. The child's thinking that they even are not even in the room with the child.
That's correct. Closed circuit television, while it was a logistic nightmare, and I've never used it, and I've been doing this for many years, some prosecutors have done it. It's probably easier to do now with the internet. I mean, you can use things like Stick'em, and Yahoo has something now called Yahoo Live, and then there's a third service on the web now where you just put a webcam on your camera and you can broadcast live on the internet, and people can watch you do whatever, do your own TV show every night at 9 p.m. Market it well enough, people will watch you. It's different from YouTube or those kind of sites, or the one I just used, Vidler. Those are already recorded. I mean, these sites are live. But in any event, that's what closed circuit television is. It's like, any one of these shows on cable TV, where somebody's in Washington, someone's in New York, and the host is in California. The child testifies from a separate room, and her testimony is beamed live to the jurors. And the court said, you have a right to challenge the witnesses against you, but it's not a perfect right. That this was good enough to give the defendant the right to challenge and confront the witnesses against him. What did the defense argue about this setup? Why it really wasn't consistent with the with the Sixth Amendment's right to confront the witnesses?
It would influence the jury, because either the accuser wasn't there, or they would remove the defendant from the room and have the minor testify without the defendant.
Right. Well, the closed circuit rule provides for the victim to testify from somewhere else. The defendant can agree to leave the room and let the kid come in court, but the setup is that the child's somewhere else and the defendant's in the room. And one of the arguments that the defense proffered or argued was, because there's a special consideration for the child, it kind of makes the guy look a little guilty. It kind of makes it like, well, we believe this happened. It has the potential to negatively impact the jury's perception of the suspect or the accused. Now, the judge can give instructions about that. There's another argument that the defense made about this. The fact that the kid's in the other room and the defendant's in the courtroom. Go ahead, Daniela.
They said that there's more of a chance of the kid telling the truth if they're face to face with the defendant. Or in other words, it'll be easier for the kid to lie from another room, not looking at the person that they're charging.
Yeah, the defense argued that there is a qualitative difference between a child testifying in another room and having to be in the courtroom and look the bad guy, well, not the bad guy, and look the accused in the eye. That's what makes the Sixth Amendment meaningful. That you have to sit in the same room and look the person right in the eye. And that's a pretty good way to produce the truth. Because people can lie all they want, but it's hard to lie in the presence of the person that you're falsely accusing. And that this is qualitatively different. That it dilutes that very important goal of the Sixth Amendment. But the court said, nah, that's not sufficient to overrule the statute. And it's a statute in New Jersey and in many other states on the constitutional basis that it violates the Sixth Amendment. The victim, however, has to make a showing, or the prosecutor has to make a showing. In order to testify on closed-circuit TV, what does the prosecutor have to show about the victim? Modia, go ahead. Fearful of what? Of the accused. But Rather than fearful of what, Africasia?
Rather than just being fearful of testifying in the courtroom itself.
Right. Very good. It can't be a generalized anxiety or, I'm afraid the jury's kind of weird and they look at me and the judge is kind of spooky and, I'm afraid of the court, I'm afraid of the process. You have to show a particularized fear of the defendant. That the defendant has a chilling effect, a scary effect on the child that would make that child unable to give a narrative or testimony. Excellent. DRH. DRH is another case that involves the Sixth Amendment. And that's the medical exam case. In that case, the defense lawyers were arguing that they had an independent right to get the little girl examined by their own pediatrician, their own forensic pediatrician, because the prosecutor had the child medically examined, and there were findings that were consistent with some kind of sexual assault. So the defendant said, well, we want the child examined by our expert. That is a very common request and very common procedure that is permitted by the courts around the country. If the FBI ballistics expert came to court or came to court pre-trial and provided a report that said this shell casing that was found in the defendant's duffel bag is consistent with the murder weapon that was found at the scene of the crime, and I based that upon my expert testimony, just like the doctor who testifies as an expert about the little girl's anatomy, the defense would have a right to take that same shell casing and bring it to their ballistic expert. Defense lawyers are very comfortable doing that. They've always had their way with that. It's just the way things are done. If there were bite marks on the breast of a woman in an assault case, and there was a forensic dentist or a forensic orthodontist who gave testimony that the bite marks were consistent with the teeth in the accused, the defense would have the right to have those bite marks, at least the photographs, or the impressions that were made, examined by their own forensic orthodontist or forensic dentist. But not so when it comes to children. And that's related to the Sixth Amendment, because the Sixth Amendment allows the defendant to challenge the witnesses against him. So if there is a ballistics expert from the FBI in my shell casing example, the defendant says, I want to challenge, I want to confront the witnesses against me. One of the ways that I am allowed to confront the witnesses against me is to have my own expert evaluate the evidence. That is part of the confrontation clause. This whole stuff about confronting the witnesses against you is called the confrontation clause. And the defendant has a right under the Sixth Amendment to an independent evaluation of the evidence against him. But in the medical exam case, the court said not in these cases. This process can be traumatizing. The defense can look at the medical records of the forensic pediatrician. And nowadays, a lot of forensic pediatricians take colposcopic photographs. They take high-resolution photographs of the child's genitalia, their vagina, and they can share those pictures with the expert for the defense, and that expert can review those pictures. The child does not have to go through a second medical exam. The court does not close the door on that, though. There may be a case where the defense gets an opportunity to have the child examined by their own pediatrician, but it's very rare. There has to be a showing by the defendant that it would yield some kind of evidence. Okay? Now, the last Confrontation Clause case is R.W. And R.W. How is R.W. like D.R.H.? Why are R.W. and D.R.H. similar cases? Yes, well done. Modia says the parallel is that the defense wanted the judge to order that the child be evaluated by their psychological expert rather than a medical evidence, rather than a medical expert. In that case, though, the prosecution didn't have an evaluation that needed to be countered like the DRH case. That's where they are a bit dissimilar. But they are similar in that the defense wanted to have an expert conduct an evaluation of the child, and this one was a psychological evaluation. And the court said this was a very pro-witness, pro-woman case. And the court ruled that every witness is presumed competent. The only reason the defense wanted this psych eval was because it was a little kid. It was a small child. Does someone remember how old the child was in that case? 3 or 3.5-year-old child. And the court said, listen, all witnesses are presumed to be competent. And unless you can show a substantial deviation from normal functioning, we're not going to allow a psych evaluation. Remember we talked in the beginning of the class about the history of skepticism and mistrust of women and children and their allegations? Well, this is an example of children not getting a fair shake. Just because they're little, just because they're young, their psychological competence, not so much their ability to understand the obligation to tell the truth, but their psychological competence is called into question solely based upon their chronological age. That's not enough, the court said. You have to show some substantial deviation from the norm. Let's take a look at what exactly the court says. In order to satisfy the substantial need criteria for a psychiatric exam, there must be a showing of some deviation from acceptable norms, such as an identifiable or clinical psychiatric or similar disorder, beyond the realm of those human conditions that ordinary experience would confirm as normal. That is a very powerful statement by a court, and very, very helpful to children and women who make accusations of sexual assault. And this is another example of the court leveling the playing field, making the courtroom fair for women and kids. Because there is always this knee-jerk reaction by the defense to get the woman or the child psychologically examined. And it ain't happening unless you can make a strong showing. Now, the defense says we need to confront the witnesses against us. We need to challenge this witness's competence. That's why the Sixth Amendment's involved. But the Sixth Amendment is not a bar or doesn't entitle the defense to get a psychological exam merely upon application. If you can make this showing, you might get one. Surely there are women and children and men who are incompetent or who may not be competent witnesses, but age alone ain't enough. The nature of the crime alone is not enough. You need to make some kind of substantial showing, and that's what the court rules. And by the way, wasn't that Anne Boleyn clip I showed you very consistent with the chapter on the history of skepticism of women and children? Here was a woman who became persona non grata at court, who became someone who was not in the king's favor anymore. So what is she accused of? Adultery and incest. Very, very sexist accusations of all the things that Anne Boleyn could have been accused of. Isn't it interesting that she's accused of, in order to behead her, adultery and incest, sex crimes?